In order for an invention to be patentable, it must fall within the definition of a patentable invention under Section 18(1) of the Patents Act 1990. This section provides that an invention is a patentable invention if it is a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. The 1959 landmark Australian case, National Research Development Corporation and Patents Commission, more commonly known as the NRDC case, found that for the purposes of Australian law, patentable subject matter covers manner of manufacture and refers to the end product of a method of invention. The judges in this case decided what is needed to define an invention as being patentable subject matter and hence being a matter of manufacture under Section 18. In this case, it was held that manner of manufacture needs to be determined beyond its plain dictionary meaning, and that the concept of patentability must be able to accommodate inventions that are yet to be envisioned, rather than to take a narrow approach that could prevent future inventions from being patentable. Since this case, the courts have adopted this broad approach and have found various patentable inventions, including computer software, business methods, and human gene sequences. Each of these patentable inventions are afforded their own process of interpretation to determine whether or not they are a manner of manufacture. In NRDC, it was held that an invention falls within patentable subject matter if it is a product or process and if it falls within a useful art. In International Business Machines Corporation and Commissioner of Patents, it was particularly held that a computer program will be a matter of manufacture, as it becomes a product when the inventor goes beyond using ordinary formulas to create something new and of use to the public. When the program becomes transformed from a mere mathematical algorithm into a program that can be used by people and is commercially viable, then it becomes a matter of manufacture and patentable subject matter under Section 18. The NRDC case reinforced that mere theories and ideas cannot be classed as patentable subject matter. In cases concerning business methods, this notion, along with the view that a business method is not the creation of a product, has been a matter of much debate. In the 2006 federal court case of Grant and Commissioner of Patents, the battle of whether or not business methods could be patentable inventions reached its peak. It was concluded that in order for a business method to be a patentable invention, it must have an element of physicality, being that the business method produces a direct effect of some sort and a transformation of the information into something rather than just being an abstract idea. In regards to gene patents, Australian courts have the opposite approach to America and Europe and have held that the isolated gene sequences can be classed as patentable subject matter. To reach their conclusions on gene patents in Australia, courts have followed the principles in the NRCD case. Particularly in the case of Darcy and Myriad Genetics, the NRCD reasoning was used to find an isolated gene sequence to be a product and a manner of manufacture, as an innovative process was created and used to isolate the gene sequence, and then once it was isolated, the sequence became something exceptionally different from the gene, allowing researchers to discover new properties and functions. Therefore, the Federal Court of Appeal held that as it stands in Australia, isolated gene sequences can be patentable inventions under Section 18. Biotechnology and medical treatments have also been held to be patentable inventions under Section 18 throughout various Australian cases, the reasoning being that there is some sort of human intervention that creates a new product and is of commercial use.